Hello everyone, welcome back to my English law channel. Ooh, just plugging something in here. Anyway, so going to look more at the Human Rights Act and how that's got to be to be judged. Obviously, that's domesticating the European Convention of Human Rights into UK law. So it was drafted in 1950 and it took effect in 1953. So it's the Council of Europe set it up, which is really every European country as far as Russia, including Russia and Turkey. Belarus is not a member of it anymore. So anyway, notice that the European Convention of Human Rights is before the European Union or even the European Economic Community. It was not set up by the European Economic Community, which is now the EU. And the Council of Europe is not the EU. It's a common misconception. And moreover, it's the European Court of Human Rights at Strasbourg that adjudicates matters pertaining to the European Convention of Human Rights. It's not the Court of Justice of the European Union at Luxembourg. The Court of Justice of the European Union is an EU court. The Court of Justice of the European Union is sometimes called the European Court of Justice, or ECJ for short. Anyway, so 47 countries are signatories of the European Convention on Human Rights, and some of them have got abysmal human rights records, like, say, Azerbaijan and Russia. So from 1998, the ECHR, European Convention on Human Rights, became part of UK law, was incorporated into it. So some of the key articles here are Article 2, the right to life, Article 3, the prohibition of torture, Article 4, outlawing slavery and forced labour, except in an emergency situation. Supposing there was flooding, we had to oblige people to put sandbags up, that would be acceptable. And it also permits compulsory military service or social service, as some countries had. But that is paid, though. Okay, there's Article 5, right to security and liberty. These sometimes clash. Anyway, come into some of the internal conflicts here. Article 6, the right to a fair trial. Article 7, no punishment without law. Article 8, right to respect for family and private life. Article 9, freedom of thought, conscience and faith. Article 10, freedom of expression. Article 11, freedom of association and assembly. Article 14, the outlawing discrimination. Later on they added things, no death penalty. That's as per Articles 1 and 2 of Protocol 6. Originally, capital punishment, of course, was allowed under this. Right to free elections, as Article 3 of Protocol 1. So you can derogate from these things. You can derogate from certain articles if there's some sort of emergency situation. But there are articles you cannot derogate from, Articles 2, 3, 4, 7, and 14. So if you derogate, saying we're suspending it or we're restricting it temporarily. So there's a margin of appreciation, each member state allowed to do things a little bit in their own way. So there's some wiggle room on these kind of things. Taking into account the traditions and philosophical stance of various countries, a key case here was Lao Tzu against Italy, application 3081406, and so the European Court of Justice heard this case in 2011. This Italian woman, she took exception to the fact that there was a crucifix displayed in the classroom that her children went to in a government school in Italy, saying Italy is a secular state, which it has been for decades. But anyway, the court said no, that's acceptable. Italy has some leeway, they're allowed to have crucifixes on the classroom wall. And so that wasn't a breach of Article 9. So proportionality is a key principle in adjudicating such cases. So what you have to do has to be proportionate to what you're trying to accomplish. Now, Lord Justice Laws was a British judge. Is that nominative determinism? His surname's Laws. He decided to go into the law. So in a Hamlin lecture 2013, he said proportionality is about minimum interference. Here's a quotation from him. Every intrusion by the state upon the freedom of the individual is in need of justification. Accordingly, any interference which is greater than is needed cannot be justified. This is at the core of proportionality. It articulates the discipline which proportionality imposes on decision makers. Close quotations. So you're trying to do something, you mustn't go further than you need to in order to accomplish that goal. De Freitas against Permanent Secretary of Ministry of Agriculture, Fisheries, Lands and Housing, 1999, is a case about this. So the judge there was Lord Clyde, and he said there are 3 questions that the courts must ask themselves to decide if something is proportionate or not. 1. Is the legislative goal they're trying to achieve important enough to warrant restricting a fundamental right? 2. Are the measures used to achieve this legislative goal properly and logically connected therewith? And 3, are the measures used to restrict this right of freedom excessive? Okay, so I'll ask those 3 questions. So anyway, the Human Rights Act took effect on the 2nd of October 2000 in the UK. So prior to that, the British citizens couldn't uphold their convention rights within the United Kingdom. They had to have their case to refer to the European Court of Human Rights at Strasbourg to do so. Since then, UK courts could adjudicate on convention rights matters. Okay, so anyway, so there's parliamentary sovereignty still exists in the UK, incidentally. So judges can't strike down laws in the United Kingdom, although they did do one on the rape marital exception issue. So maybe they can, but that's the only time they've ever done it. So anyway, sections 3 and 4 of the Act have produced some creative tension. So remember, section 3 requires, of this Human Rights Act, obliges courts to interpret statutes as consonant with the convention rights in as much as possible. If it's impossible to do so, then the courts can say that they issue a declaration of incompatibility. It doesn't allow them to nullify that law as repugnant to the convention. So only the Supreme Court, Court of Appeal and High Court are empowered to make this declaration of incompatibility. Then it's up to Parliament to choose to amend legislation or not, because, as I say, parliamentary sovereignty is maintained. Okay, so the Human Rights Act contains a number of provisions to uphold human rights, such as Section 2. It obliges courts in the United Kingdom to consider previous rulings of the European Court of Human Rights, and that informs the way that they interpret the Convention. Section 3, it obliges all legislation to be read in as much as possible in a way to uphold Convention rights. Okay, so this is how courts try to interpret domestic legislation, to try and make it consonant with the Convention where they can. Section 4, this allows the courts to issue those declarations of incompatibility if primary legislation collides with convention rights. Section 6 says it's illegal for any public authority to enact in a way which is incompatible with the European Convention of Human Rights. Now notice it might not be compatible, but not incompatible either. Here's compatible, here's incompatible, but there's a gap in the middle. So public authorities might go on later to what public authority is. Is any agency of the state or anything performing quasi-public functions. Section 10, this allows this quick procedure to remedy the situation. If a declaration of incompatibility is issued, how Parliament could rectify the situation rapidly. It doesn't oblige them to do so. So Section 19, that obliges a government minister who's forwarding a bill in Parliament to provide a written statement explaining how the bill is consonant with the Convention. So there might be some changes to the Human Rights Act. In 2014, the Conservative Party, they published a document entitled Protecting Human Rights in the UK. So it said that if the Conservative Party was re-elected, which it was, they would sever the connection between United Kingdom courts and the European Court of Human Rights. They said that the UK courts would no longer have to consider rulings made in Strasbourg. Okay, so it wanted to have a more distant relationship with Strasbourg. So anyway, so then David Cameron, as Prime Minister, said that his government was going to repeal the Human Rights Act and introduce a British Bill of Rights in its stead. Okay, and he said this is about achieving the right balance between individual rights, national security, and effectual governance. but that's not actually happened. So Dominic Grieve was Attorney General of the Conservative Party. He's a QC, Conservative government, and he said, no, that would be terrible. It would wreck the UK's standing. It would bring the United Kingdom into disrepute. So so far it hasn't happened. The EU had a justice subcommittee, and they looked into what would happen if this was done, and they said it was terrible. Not surprisingly, that's what we would undermine the EU. Okay, so anyway, let's look at where the sources of law are. So we know that English law often comes from statutes, but it comes from other things as well. There's common law. Obviously, EU law is now part of it. Rulings of the European Court of Human Rights. Civil law systems are quite different as civil law as in Roman law. So one of the key things about common law is the way that case law matters so much and judicial rulings, whereas in civil law systems they look to previous cases, but they don't have binding precedent as common law countries do. So France is a key example of a civil law country. Treaties are part of their legal system. Statutes or loi. There are also regulations, règlement. So yes, that goes up in tiers. They've got different kinds of legislation. The Constitution is the supreme kind of legislation. So the French Parliament can only pass laws which are consistent with the Constitution. There's a constitutional court, le Conseil constitutionnel. Many countries have that. Armenia's got one, for example. And this verifies that these statutes do not break the Constitution. Now, in England and Wales, there isn't the same hierarchy, that there are tiers. The tiers of courts, but not tiers of laws. So there's parliamentary sovereignty. So statutes you might think are the highest form of law. That's not really so. But we know that EU law prevailed over national law. There was a factor-tame case, the famous case about that Spanish fishing vessel in the 1980s. So statutes to be interpreted where possible to be consistent with the European Convention on Human Rights. And remember, they are not they're not thrown out simply because they collide with the European Convention on Human Rights. So anyway, there are parliamentary statutes in France, and these go through the legislative process. There's the government will have a bill, projet de loi, as in a proposal, and the bicameral French Parliament has to approve it, l'Assemblée nationale and le Sénat, and that the president will sign the bill into law, be published in the official journal Le Bulletin, and that's it. Then it's law. The secondary legislation as well there. So, but French law is different in that it's got codification. So the whole law is meant to be found in a single system and not in bits and bobs that are very difficult to fit together. Remember watching a lecture by Lord Bingham, some case he sat on, and there's so many bits of legislation, contradictory legislation, did this one repeal that one or reformulate the other one? And it's very, very complicated, and eventually they found that the law they were trying to educate no longer exists, it's been repealed. Okay, so France has got the Civil Code, the Civil Procedure Code, the Commercial Code about different areas of law and what you have to do. However, not everything can be found in these codes. There are other extraneous pieces of legislation which have amended these codes. You can find codification in all Roman law systems. There is no civil code in English law saying out this is what the law of contract is. So some statutes have tied up the law, but they're not as overarching, not as united as you have in a Roman law system. So codification streamlines things. It's got its upside and its downsides. It's simpler to find, and it enables people to know what the law is. Codification of laws makes us sure what the situation is. And then it allows you to draft legislation more easily. It makes it more rational, and it systematizes things. In civil law systems, then you have an overview of the law, though there are increasing different sources of law. So some people say the trouble with codification is too difficult to change, and it's hard to reformulate law. So case law is not actually part of the law in France and Roman law systems. So judges in France, they have to interpret the law. Their job is to apply it. Remember, a Spanish lawyer, obviously, as the Roman law system said, in theory, you could invent a computer who would simply apply the law to the facts, and that would be that. There shouldn't need to be there shouldn't be any need for interpretation. In practice, there is a bit of a need for interpretation. So judges don't evolve legal rules in Roman law systems, and they don't have to follow precedents, as I said. But some people say this promotes certainty, because I want to do this. Is it allowed or not? And that's easy to know in France. Okay, so case law is not actually part of this, but they do look at the decisions of other judges, previous judges, particularly in administrative law. So that's enough for the moment. Toodaloo.